Thank you all for returning. So for this panel, we have three terrific scholars and the title is Bringing the Social Science Approach to New Frontiers. So in order of the program, we're first going to hear from Olabisi Akinkugbe, who is a professor of law at Dalhousie University in Halifax, Canada. Emilia Justyna Powell, who is a political scientist from the University of Notre Dame, who's done wonderful work on Islamic law. And Weijia of Antonin Scalia School of Law at George Mason University, who is, I will add proudly, a doctoral graduate of the University of Chicago Law School. So we're thrilled to have her back. BC, you can take it away. Thank you so much for joining us. We're really happy that you all said yes.
Okay, so thanks a lot, Professor Ginsburg, and huge thanks to Jared and to Nima for all the work they've done up to now. I thought that my own presentation today, having read the piece put together earlier on by discussed in the previous panel, should probably look a different direction than the mainstream accounts of international law that we have heard in the first panel. I sort of taking an approach that looks at the others, and if you like, linkages in international law, whether you speak of international trade law or international investment law, to ask the same questions about how the study of these particular areas of international law have mapped out theoretically and methodologically with a view to understanding really what they have privileged, what they have opened up, and what they might yet advance in our understanding of how the diffusion of knowledge in the international economic law sphere has occurred in the continent of Africa particularly. And so mine is about a reflection on the value of socio-legal approaches to the study of international economic law in Africa. And pluralizing itself by way of approaches acknowledges something which the paper by Chilton, Abebe, and Ginsburg really notes about the fact that there are different paths to which one can methodologically engage with specific substantive questions, whether in international law or international economic law. And so for me, this is not about, again, saying which one within the socio-legal approaches I'm going through, than to draw on the body of work to then advance this hypothesis, which starts with this first one, that the dominant theoretical and methodological approaches to contemporary international economic law reinforce Western-centric views, and that notably African countries, Latin American counterparts, and the Caribbean islands, and other regions outside the Western Hemisphere are playing a catch-up game in the research, teaching, and practice of international economic law. When one comes to that, you come to it from various traditions, the historical perspective, and the subsequent evolution in the post-colonial era. Now, the rest of my time will try to dovetail three particular areas. One I call the challenge of the history and evolution of international law, broadly speaking. And in this part, my claim is this, that look, we cannot think about international economic law outside of international law itself. A lot of work has been done and continues to be done about the history of international law, and claims about its evolution have been done. But my first point is to leave on the table the idea that a lot of the questions we've asked about the history, blind spots, biases of international law can be directed at the subfields, if you like, of international economic law and international investment law. So they are not, in a sense, free of the type of claims that Professor Gathi made in his own presentation, nor are they in a better position to shed light on how the understanding of international economic law in the African continent has been conceptualized. Part of my research for today's talk took me into a very interesting article by Detlef Vax in the American Journal of International Law, in which he articulated international economic law articles in AGIL from when it was established to 2006. and divided them into 4 periods, which he calls 1914 period, La Belle Epoche. Forgive me, I don't speak French. The 2 interwar decades, World War II and post-Bretton Woods epoch, and the last post-Marrakesh decade, which he further says is evolving and has not crystallized one way or the other. I find that interesting because until perhaps the post-Marrakesh decade, one does not situate Africa in this discourse with any meaningful claim to the development of international economic legal knowledge for how it influences the global scale of understanding of this area of international law. If we leave that, right, and pause the 3 first categorizations by that in the buckets of colonial and early post-colonial legacies, and what this means for GATT and how African states could not effectively engage, and the failure of NIEO, perhaps we can then move forward to a more contemporary era, which is the post-Marrakesh era. My claim in this area is simple. It is that, as Ginsburg, Abebe, and Chilton really said, there's value to adopting social sciences approach, broadly speaking, and sociolegal approaches in particular to the study of international economic law in Africa. What perhaps strikes me when I read that article is the idea that the authors were trying to remind us that they are not in this box where labels should be fetishized. And that struck me so strongly because in my understanding and scholarship in African continent, hardly do you have people really claim the label of legal realists, or nor are they too happy to be institutionalists, right? Now, you might say that there's third world approaches to international law, but there's the big question of how that really is effective in the geography of the African space outside of the continent. And so I found that very striking as just an anecdote to some of the other points I'll make. I find it a little bit more interesting when one thinks about the type of scholarship that has been produced from, for and by, I should say, African scholars in recent times. And I'll speak to some of the books that have been written that adopt not just sociolegal approaches, but they've combined it with international relations approaches. And some of them have really been empirical. And I'll tease out in the last section some of the challenges that comes with doing that. I can say it here. I did a sociolegal approach. I undertook a sociolegal approach in my doctoral work at Ottawa University. It was more analytical than empirical, but the challenges of undertaking an empirical research were some of the reasons, for example, that I left it aside. And I think this is a challenge that didn't come out so clearly in Ginsburg, Abebe, and Chilton's article about how well equipped legal scholars are to undertake the tools of empirical research that social sciences are perhaps more advanced in doing. In my own work then, at least in the purpose of this presentation, what I see happen is that the study of international economic law in Africa and its research and perhaps teaching to a large extent reinforces some of the positivist claims and underpinnings of international economic law, which unfortunately only produce one thing: a narrative of failure about these particular regimes on the continent. I can give an illustration about this to just put some maybe more context on it. We can think about the informal economy in the African continent vis-a-vis the formal economy. A lot of international economic law, the hypothesis, if you like, a lot of international economic law study and scholarship is predicated on the notion of the formal economy. Things you can readily ascertain, those you can account for through data. But quite unfortunately, the history and contemporary reality of African states is that a lot of their trade, for example, happens outside of the safety net of the formal economy. Now, that's a challenge. How one goes past that methodologically is a huge problem, right? When you put on the facts, the reality is that a lot of the borders through which these cross-boundary and transboundary trade regimes occur are really porous. So there's no way for you to really gather that data that we're talking about here that we have challenged. But that's at the local level. The question is, what does this do for the international accounting of this particular area of law? And that's where I see value to that. The challenges that one might face in doing this type of research shouldn't be a deterrent to undertaking it. It may be that part of the questions one has to set is to be very limited in the scope in which one is going to set out to look at it. It may be that one is very specific about the industry that one wants to look at. And that's why I find the work of my friend Makavani very interesting. She did a very interesting uh, complex matrix of sociolegal approach, TWAIL and IR, looking at patent regimes in Africa, in Brazil, in Nigeria particularly, I should say, Brazil and India. So, and it came out with a very fascinating outcome. It won the Society of International Economic Law's Hart Prize 2 years ago. I leave that and come to the next question. Something which Chilton, Ginsburg, and Abebe called for, which is that they want more focus on the question of how international law works, right? As opposed to how it has been. And I think that's another illuminating potential that socio-legal approach to international economic law brings to the table. I was part of a recent edited volume by James Gaffey. And part of what we sought to do in there is to really get case law out of African international courts to really not just read them through the lens of effectiveness and compliance, but to see what are the uses that this decision or purposes these decisions fulfill in society. This may be social, this may be political, there may be, just things by which the activists who bring these cases to court seek to question notions and put pressures on government, but their value that are brought to the understanding of the scholarship in this area, and they are not any less valuable for what they are simply because they are not wedded to our understanding as we've come to know them. So I think the invitation by Ginsburg, by Abebe, and by Chilton really is one that augurs well further for an inclusive international legal scholarship. It's one that avoids being predicated on cosmetic allegiances to one or the other school of thought, and focuses, I think, as they've invited us, on the practices of international economic law, softens, I argue, defensive enthusiasm and corrosive skepticism that characterizes the history of the field of international economic law. I think the specificity of international economic law belies the universality that it traffics, and it fails to pay careful attention to the fact that regions, spheres, and spaces across the world really tease out scholarship, research, and knowledge, and the production thereof in different ways. And I think we have to come to a comfortable space where we appreciate the value of the overlapping nature of these areas, and perhaps nuance needs to be more of the word that we play out more than seeking it to be in one way or the other. As I'm cautious of my time, I'll move forward to try to then tease out an area where I call some practical problems, considerations, and limitations for African international economic law scholarship. I'll be remiss not to mention that all is not gloom on the continent. Post-Marrakesh era has seen a very vigorated, production of legal scholarship, which I discuss in my paper, which I'm sure will be available at some point. There's been production of special issues. There have been production of, edited volumes, mostly from the African International Economic Law Network. Now, what is interesting about this is that what social science approach really also helps us to do, which is not in the core of the substantive generation of knowledge now, but thinking of the publication dynamics and which houses get to publish them. If I publish with a publisher in Lagos State, Nigeria, chances are that nobody in the world will know them, right? As opposed to being published by Oxford. Now, how many Nigerian scholars do Oxford publish every year? That would be an interesting social science research. But if you already can glean from what Professor Getty's presentation says, which I think dovetails this quite interestingly very well, you can ask questions of how social science research can shed light on a question as simple as there is not sufficient scholars that study international economic law. That's not true, right? It's about how we look at it. I think one last point I want to leave on the table is in relation to the challenge. I think a lot can still be said about the value of this particular approach. Data collection remains a huge problem in the African continent. I think the ease with which Professor Gathi has undertaken the scholarship that he looks at, for example, in the AGO, may not easily be extended to many fields, or universities, or even faculties on which one might want to do this kind of research. I'm involved in one that is looking at the teaching and research of international economic law in Nigeria. And we've had to just collate syllabus and look at the materials that are used to teach. It's not so surprising for me, I should say, but a lot of it is still about, many of the figures of yesteryears that produce knowledge that, we've questioned to a large extent their applicability. And that, so I think if you look at the box of data collection on the one hand, the other one that goes with that is the contextual analysis that needs to follow that. I don't think that a lot of the schools in Africa, at least in Nigeria, I should say, really have gone the critical route. A lot of them still teach international economic law and by extension international law in a very doctrinal way. Now, the challenge with that is that it risks continually reinforcing the very foundations that scholars have questioned about the application of this particular subject. I've spoken about the training and empirical analysis in empirical analytical work that needs to be undertaken. And if being in the global north provides that kind of research, one can also imagine then what it means for scholars who are on the continent of Africa, on the other hand. But it doesn't also paint a bad picture. It shows the strength that analytical, as opposed to empirical work on social science approaches brings to the table. And in my own view, my last sentence is that I think the value of what Ginsburg, Chilton, and Abebe have said, maybe they deliberately understated it in their paper, is that a lot of scholars are already doing that on the continent of Africa. And what it shows is that there is a promise beyond the Western-centric ideas that we've come to celebrate as the epicenter of knowledge production in international economic law. Thanks.
Thank you so much, Professor Akinkugbe. That was wonderful. And now we will turn to Professor Powell.
Thank you very much, Tom. I will speak on how the social science approach relates to comparative international law and how it helps us understand and move the study of comparative international law forward. I believe that the social science approach can add much insight into our understanding of the dynamics, the day-to-day functioning of international law, the reality of international law, by going beyond historical and normative description and focusing on a scholar's ability to construct a generalizable theory. In particular, I believe that the social science approach helps us explain how does the nexus between domestic legal traditions and international law functions in practice. For sure, there are some questions within the study of international law that do not lend themselves to the social science approach. Yet, depending on the question we are asking, methods that are offered by the social science approach can be very useful. For instance, we can ask, is international law effective? How does it work in different contexts? How do considerations of strategy and power politics commingle to curtail the effectiveness of international norms and organizations? So then understanding, theorizing, and scientifically exploring how different states, and more generally, different geographic regions or different domestic legal traditions conceive of international norms and international institutions is definitely a worthy scholarly endeavor. Ultimately, the reality of the global order and its underlying normative framework, international law, are interpreted via the lenses of those who use it. So it's super important to understand the practice. Of course, there are many ways in which the scope of international law is general. So international law rests on an assumption that a common, all-embracing legal framework should govern behavior of all states and all subjects of international law. So there's a lot of generality to the pathways for actors' behavior as outlined by international law. There is somewhat expectation of a monolithic behavioral output, but that's not the case. That's not the reality. Why not? As the work of several scholars in comparative international law show us, local, so domestic customs, laws, and norms affect how states view, teach, and practice international law, because no part of international law has been created in a legal vacuum. There's always influence of domestic understandings of how justice and law should operate. So if we believe that many issues of international law are interpreted via the lenses of domestic legal education, local norms, custom, and legal awareness, or more broadly, legal tradition, then questions of that nature call for the methodology offered by social sciences. So I want to draw our attention to the concept of external view of law, as mentioned by H.L.A. Hart and reiterated by Chilton, Ginsburg, and Abebe. If we really focus on practice of international law, if we want to evaluate it, we in a way engage in these external ideas about international law. In this context, I want to add that it is crucial, while engaging in the social science approach, to have a sound theory. Without the theory, a social science approach, in my opinion, is mute. And I also appreciate that the social science approach discussed here is understood as multiplicity of methods, not only large and cross-sectional time series data with statistical patterns emerging, but it's also a small, in-depth case studies and a variety of other methods. There are also purely theoretical approaches. I do want to emphasize that oftentimes with my own work, I have been criticized by scholars who believe that if I attempt to quantify something, such as characteristics of domestic legal tradition, in my context, it is the Islamic legal tradition, I am somehow trivializing that. However, to quantify is not to trivialize, as Beth Simmons wrote. It is just our effort to document how serious or how important we believe certain practices or understandings of international law are. While conducting the social science research in the context of international law, and for that matter, any other context, it is important to underline that this approach or results of such approach are not meant to be a conclusive statement on a particular topic, because social science largely operates on the basis of likelihood and probabilities. This is in particularly true in the context of large N analysis. It is also worth mentioning that I believe the social science method is particularly useful to develop and test mid-range theories, not meta theories about conditions which international law has effects in different contexts, different regions, different realities and practices. I want to highlight or talk about how I found the social science approach to be useful in explaining the nexus or the relationship between the Islamic legal tradition and international law. So the Islamic legal tradition present in Islamic law states, as I call them, has its own partially distinctive view of thinking about international law and global order. So the practice of international law, the interpretation and view of legitimacy of international law is quite distinct in states representing the Islamic legal tradition. However, what we see in the scholarship very often is that there is this assumption of vast dichotomy between international law on one hand and the Islamic legal tradition on another. And there is expectation that there is continuous disagreement between those two legal traditions. Another assumption that I found in the scholarship that's wrong is that the Islamic law states are a monolith. So all Islamic law states perceive international law, practice international law, view international law in the same way. So then, while outlining broad similarities and differences between Islamic law and international law is certainly useful, one cannot ignore the reality that Islamic law states category is not a monolith. So Islamic law states are not Islamic to the same way, in the same manner. So in order to understand how international law is effective in Islamic law states, we have to account for the variance of secular law and Islamic law in the context of Islamic law states. And I have been able to measure this nexus by engaging in large and cross-sectional time series analysis that are also deeply informed by qualitative in-depth studies and interviews. So then what does such research suggest based on the social science? I found that the relationship between the Islamic legal tradition and international law is not really about fundamental clashes or collisions of values. I also found that it is incorrect to make blanket, all-inclusive statements about how Islamic law states practice and understand international law. A much more nuanced and complicated picture emerges. In the context of International Court of Justice and other methods of peaceful resolution of disputes, I have found that different Islamic law states are attracted to different forums. In particular, Islamic law states that embrace more secular elements in their governance are more acceptant of the jurisprudence, compulsory jurisdiction, as well as compromissory jurisdiction of the International Court of Justice. I believe that the social science method, while very valid to ask and answer many questions, it may not apply to all areas to international law. However, it can move our study of comparative international law forward. However, again, we have to recognize the weaknesses of that approach. We have to try not to overgeneralize. The importance of a sound theoretical framework from which solid, testable hypotheses flow cannot be overestimated. It's absolutely crucial to engage in the social science approach in the correct way, to acknowledge that there are assumptions and acknowledge some of the limitations. Nevertheless, I believe that it's a very useful approach. Thank you.
Thank you so much, Professor Powell. That was terrific, and I have plenty to say, and which I will do in the comments. But let's now turn to Professor Rao.
Thank you, Tom. Let me see if I can share my slides here. Can you see my slides?
Yes.
Great. So thanks again for having me on the panel. It's a privilege to be part of this conversation. So my essay focuses on the two limitations that Ginsburg, Chilton, and Abebe pointed out in their leading essay, that the social science approach to international law is largely positivist and retrospective, in that social scientists refrain from making normative commitments and instead focus on describing the world as it is, by looking backward to existing data. So building on their proposition, my essay argues that the social science approach to international law can be normative and prospective in the sense that we can use the findings based on existing data to inform future policy making and institutional reforms. So the field of international law is currently facing significant challenges and undergoing rapid changes. WTO members are contemplating various reforms of the system, including reforming the appellate body, which has ceased functioning amid fierce criticism from the United States. In the international investment law sphere, investor-state dispute settlement is facing a legitimacy crisis. States have raised concerns over lengthy and costly proceedings, inconsistent decisions, lack of arbitrator diversity and independence, etc. So countries are now working on reforming ISDS under the auspices of UNCITRAL Working Group 3. Because of the many stakeholders involved in this reform debates, it's often challenging to get all the countries on the same page and have them reach consensus on which reforms to pursue. Taking ISDS as an example, while countries shared concerns over ISDS and its various problems, their views diverge when it comes to which paths to take to solve these problems. So this essay argues that social science research can help inform such debates by identifying the causes of the problems. So the existing social science research in international law has largely focused on empirically examining and documenting the problems themselves. For example, several empirical research projects on ISDS focus on documenting how expensive ISDS has got or how lengthy these proceedings have become, but not that many projects have explored what have caused the excessive costs and a delay in ISDS proceedings. So without understanding the causes of the problems, it is difficult to put forward tailored reform proposals that will convince these very different stakeholders to get on board. So while other social science methods can also be used to understand the causes of real-world problems, for the sake of time, I will focus on empirical methods here. So causal identification in international law research can be challenging. In the domestic setting, many empirical studies that evaluate policy merits or its effectiveness can exploit variation at the jurisdictional level. It can be more difficult to find such variation in the international law sphere, which is meant to be international and universal. But we can still exploit other variations, such as variation in the underlying treaty provisions, variation in the legal claims being brought in dispute settlement, or variation in international law participants themselves. So to the extent that our empirical design is guided by research questions specific to the potential causes of the problems we observe, it is possible to leverage these variations to identify the effects of those underlying causes. So for example, in a recent paper that I wrote on domestic politics and settlement in investor-state arbitration, I examined the question of whether and how domestic politics affects state settlement behavior in investor-state arbitration. This project is motivated by an institutional problem, which has been empirically documented in the ISDS literature. That is, ISDS proceedings are known to be lengthy and costly. So one cause of this problem can be that states are unwilling to settle cases because of domestic political influences. So settlement rate in ISDS is very low, only around 20% of the cases are settled. Because governments are the respondent party in these disputes. They might worry that by settling with foreign investors, they risk being perceived negatively by their domestic public. So this is already supported by anecdotes and news reports. Governments that settle ISDS cases have been criticized for capitulating to foreign investors' demand and selling out using public money. But how to test this empirically, that anticipated domestic public pressure actually affects state settlement behavior. So I exploit variation in election timing in the respondent states because electoral disapproval is more likely to translate into loss of political power as elections get closer. Elected officials likely will become increasingly cautious with settling with foreign investors. And because a country's election timing is plausibly exogenous to individual case merits, this empirical design allows us to draw causal inferences about the effects of domestic political pressure on settlement outcomes. So the empirical findings support my hypothesis. Settlement becomes less likely as it gets closer to the next election in the respondent state. And this suggests that domestic politics does affect state settlement decisions, which has led to a delay and in some cases failure to settle. So this is one cause of the problem of excessive length and costs associated with ISDS proceedings. So how might this empirical finding inform institutional reform? Well, if we believe that more settlements is one way to reduce the length and costs associated with ISDS proceedings, then we need to find ways to insulate the decision makers in respondent states from this kind of domestic political pressure. In domestic political influence. And this means that institutional arrangements required to address the problem could be more at the domestic level than at the international level. And in this regard, Peru has set up an interagency commission specializing in the prevention and handling of investor-state disputes. So once this commission is notified of a dispute, it is responsible for drafting reports assessing the dispute and actions to take, including the possibility of settlement. By having a specialized commission with experts in the field generating reports, analyzing the facts and the legal claims in a dispute, and giving detailed reasoning regarding why settlement is the desirable strategy here, this institutional arrangement helps mitigate potential domestic backlashes against settlement and therefore has a potential of insulating decision makers from domestic political influence. So this is an example of institutional reforms specific to address the underlying causes of a problem. And this approach can be extended to a broader set of international law problems we face today. For example, countries share concerns over arbitrator bias in ISDS. But what's causing arbitrator bias? If we find evidence showing that double hatting has compromised arbitrators' impartiality when hearing cases, but no evidence that reappointment incentives per se lead to biased decisions, then maybe a more incremental reform, such as refining arbitrators' code of conduct, is a more desirable solution to the problem than an overhaul of the entire ISDS or replace it with an investment court system. Because all reform proposals come with trade-offs, it is particularly important to get a comprehensive understanding of the problem we face before rushing to implement a reform that may not get at the real cause of the problem. So the social science research can be helpful in this regard. So while social science research describing the world as it is and documenting the problems we face is very valuable, we also need to do more to identify the underlying causes of these problems, especially in the context of international law, where tailored reforms are needed to get a wide range of stakeholders on board. Thank you.
Thank you so much, Professor Rao. So we have some questions already, and feel free to raise your hand if you would like to do more. I'm going to start actually by saying a comment, if I can, on a couple of these papers. They were a wonderful set of interventions. Emilia raised a point, a really important point, which came up in the chat the last session, which is what's the role of theory, and where does theory come from? And in a way, James's project was kind of an example. The theory comes from outside, the project, and then you go forward and you test it. I guess I want to make the point, and it's something that I learned from Greg Schaefer in his SocioLegal work, that theory, of course, is also grounded in observation of the world, and that sometimes our empirical work helps formulate the theory or helps refine theory. And one example I have is actually the book which BC mentioned, which was edited by Professor Gatti, and obviously it'd be a big distraction to go too far into it, but basically they were looking at regional courts in Africa. And what they found, like, if you were to just go using the existing theory, which has kind of come out of the European Court of Justice and such, you would ask, well, are countries complying with the decisions of this international court? And maybe they started by looking at that, but that's not what they found. And so then, armed with data from having looked for this other thing, they realized that many other things were going on with these courts, and the decisions were being used in ways that no one had really ever theorized before. And I think that's a good example of how it works in general, that there's always this back and forth between the real world and trying to formulate hypotheses or theories at a certain level of abstraction, which is what theory is, and then going out and testing them. It's always back and forth in my view. So that's kind of a reaction and a comment, but I really liked everything you said, Emilia. On BC, I wanted to just say you raised a couple interesting things, like, isn't this a big challenge? How do we go forward, given that there's so many skills that are necessary to do all of this? And I think the answer is do what I did for this paper: collaborate. Yeah, that is, work with other people. I know Mark Pollack was here. He's a political scientist who's worked with Schaefer. Emilia's a political scientist who worked with lawyers. There's lots of ways to collaborate to do gains from trade, if I can use the term, and that's useful. And then you raised a really interesting point on informal data, and that, of course, is a major challenge. And it's something that we don't talk much about in the social sciences, but it's the challenge of measurement, basically. Like, how do you, let's say you have this concept that there's, international trade going on, but you're only using measures that are drawn from the IMF, and they're missing massive amounts of stuff that's going on because of their data collection methods. So that's exactly where one needs to be really aware of the context and to recognize the context that do matter. Now, I want to raise two questions from the chat, and then I will turn it over to the professors. So for Professors Akinkugbe and Powell, to what extent will data collection solve rather than perpetuate longstanding problems of formulating Western-centric questions and hypotheses, in your respective realms of post-colonial Africa and the Islamic world, given the Western habit of treating them as monolithic? I think we both spoke to that a little bit, but maybe you could say a little more. In fitting international legal research to these spheres, do prospective researchers need to develop new critical tools before embarking on the empirical project? That's one question. And now I'm going to ask one of Professor Rao, and then turn it back to you. In identifying the causes, social science research enables us to map or explore the causal link and mechanisms that shape the outcome. In your case, the outcome of interest is institutional changes. And that's a comment, but maybe you could speak to that as well. And finally, I'm going to say one last thing, which is there a risk, Professor Rao, this is from Mark Pollack, that researchers aren't always sufficiently conscientious about spelling out the policy implications of our work and focusing our work on policy-sensitive variables. How well are we doing as empiricists in creating useful knowledge for policy? So with all that on the table, I'll first turn to Professor Akinkugbe.
Thank you very much, Professor Ginsburg. That's a very interesting question. I think before I come to the question of whether data collection can perpetuate or solve the problem, I think I like what you said about the theory point, and I think perhaps enough emphasis has not been made in the course of graduate programs about potential theoretical contributions, right, of doctoral work. I haven't supervised a lot, but one thing I struggled with in the course of my doctoral work, for those who are students here, which I completed in 2017, was that you struggled between trying to make a substantive contribution, something which people will say, yeah, he did this about investment law or something, and on one that merely tweaks the lens to which we look at questions. So I was satisfied with just having something that says, look, if you ask questions about the fact that regional trade agreements are embedded in a contested space of political, economic, and social thinking by nation states, different ideas will emerge, right? And that was okay, my doctoral committee said. You don't have to tell us what emerges. That's the idea of pluralizing knowledge, right? That's the challenge. And that's what I believe the article by Ginsburg and Chilton and Abebe are pushing us to do, right? On one part. I think the idea about that then is if you come to the data collection question, I don't think it will perpetuate post-colonial thinking, right? I think the idea is that we go into this, and I think this agrees with what Professor Powell said, with the idea that Africa as a continent itself is heterogeneous. That's its beauty, right? Professor Gavi's book right there, has argued that a distinctive feature of African regional trade agreements as legal regimes is their heterogeneity, right? And within Nigeria as a country, there are so many differences from regions to regions, right? So that's one thing. And I think what you do by eliciting that kind of research, if you have access to it, to the mainstream domain is to call for more nuance. I said this in the course of my presentation. I didn't have time to speak about it. You see, you pluralize them by showing, for example, in the context of trade. This is the hypothesis that's out there, that regional trade in Africa is a foregone issue. Trade does not happen in the way you know of it in the EU and under USMCA, right? Like those guys just they just like to set up regional trade organizations and they don't care what happens afterwards. Now, that's untrue, we've come to know. How so? Because data is imagined showing how informal trade goes on. You know what else is interesting about that data? The actors that are in that economy, they are women, right? They do a lot. And so you can escalate this and bring out very interesting thoughts and lessons that are really not wedded to GATT, WTO, and EU frameworks that I have nothing against, but just not my style at the end of the day. All right, I'll stop. Thanks.
Thank you so much, Professor Powell.
I want to talk to the issue whether we are using the social science approach on the Islamic legal tradition, we perpetuating certain dynamics. So I want to provide hard social sciencey proof how I debunked some expectations. So number one, the social science approach showed the inherent multiplicity of the nexus between Islamic law and international law. And two, there really is an expectation in the scholarship that Islamic law states are not in favor of institutionalized international law, in particular international courts, such as, of course, the International Court of Justice. By using the cross-sectional time series data, I was able to show that actually in territorial disputes, so disputes over a very highly sensitive issue, which is territory. In those disputes, Islamic law states attempt non-binding third-party methods of resolution, so mediation and conciliation, more than non-Islamic law states. Also, and more surprisingly, Islamic law states use international courts. They attempt resolution of territorial disputes in international courts, percentage-wise more than non-Islamic states. I don't think I would have been able to show that by not using a social science approach. I could say it should be like this, but I couldn't make a statement it is like that. Thank you.
And Professor Rao.
Thank you. So on this question about whether we should be conscious of the policy implications when doing empirical research, I think the answer is yes. And here actually I echo Ginsburg, Chilton, and Abebe's point in their paper that social scientists should refrain from normative commitments when it comes to when they start empirical research, even though based on the empirical findings, we can draw normative influences. In terms, and because of the stakes here are very high, because the empirical research, empirical findings can be used to inform policy making, to inform institutional reforms, social scientists should be particularly cautious about the alternative stories that may explain the findings. And this point to the importance of clean empirical design that will make us able to draw real causal inferences. I think that's also the point from Vala's comments. And I also want to echo Professor Powell's point that theory is very important. So I think good empirical research should be guided by solid theories and theoretical issues, questions, and also empirical findings can be complemented by here I'm talking about quantitative research findings, can be complemented by evidence from qualitative research, such as survey results, interviews, anecdotes. So I think I would say to be conscious of the policy implications of the empirical research that we are doing here, we should use a whole range of methods social science methods to inform our findings. Yeah, thank you.
Thank you. A couple more questions have come in. This is from Selman Aksunger for Professor Powell. International law from an Islamic law perspective has generally been studied by Sharia scholars or Islamic law scholars and historians. Why do you think that is? And maybe what are the consequences of that? And then Arnold Pronto raises the question is, could we use empirical methods or the social science approach to study the formation of international law itself, such as identifying state practice and opinio juris for custom, etc.? So what are the panelists' thoughts on that? Why don't I turn it to Emilia first?
If I understand the question correctly, it is that the issues of Sharia or CR in particular, the Islamic international law, have been advanced by scholars of Sharia, yes, Islamic law scholars and not other scholars. Well, there's a variety of scholars that study CR, so Islamic international law, and also the nexus between the Islamic legal tradition and international law. Of course, we're going to have quite a bit of scholarship coming from the Arabic language literature, as well as Farsi or Persian language literature, and usually these are going to be scholars of Islamic studies. So yes, it is largely correct that there are few non-Muslim scholars studying the issue of Islamic international law, perhaps. And there are very few of scholars that are firmly based, let's say, in political science and international law. that study the issue of the Islamic legal tradition in the context of international law. Does that cause issues? Yes, because when I was trying to finish my book, I had to make sure that it appeals or it speaks to a variety of disciplines, including the Islamic law scholars. And again, presenting methods of quantitative scientific inquiry to Islamic scholars sometimes was interpreted as an attempt to trivialize Sharia, which I was not doing. So in a way, the question is absolutely on target. Thank you.
Professor Akinkugbe.
Okay, thank you very much, Professor Ginsburg. Just something on that question by Arnold. Then I'll have a question for Professor Rao. Okay, I think that something which Professor Schaffer mentioned in the course of the last, I don't know if you were around, Arnold, panel, is the role of power, right, in relations of states. I think we're cautious here. I think it's come out in a lot of the provisions that we're not holding the two-valve social science approach up as the there of solving all the problems. And I think Professor Gethi's presentation really injects a little bit of race. And if you think about that in the context of indigeneity, in the context of African persons, or if you think context of African Americans, to the role of the creation, right, of international law in its historical evolution, then you would see that, I mean, even if you put on the one side social science as a broad category, and then you inject into that, you know, specific norms or strands of power relations and what, and you know, I have forgot the other word I was going to say now. Then you can understand that, well, it's clear a lot has been done about that, and questions have been answered about the fact that, yep, we now know more that international law was never a savior for many folks. And I think this same type, I won't commit the very thing we're warning against, to make an opinion about practice and opinion juris when I haven't done the research, right? Which is one of the very things we're trying to avoid. So I won't go there for that one, is my response. Well, for Professor Rao, thank you very much for your response of the other time. I was just curious about your assertions that we should come to social science research perhaps without a normative take, right? And it just sparked up the notion of bias in my mind, right? And thinking about what's your role, what's your thoughts on bias? I don't think we come to research without some sense of bias. We arrive with particular thinking, and it leans to the theory of it, but there's something, right, that has taken it. So I'm just interested in your thought on the bias question. Thanks.
Thank you very much for this question. So Arnold's question, actually, the point I'm going to make, I think it's along the same lines as Professor Akinkugbe's point. Is basically the broad scope of social science methods that we are talking about here are actually helpful for us to obtain a better understanding of the formation of international law, because for international customary international law, this kind of issues, I would say empirical research, it could be challenging to do empirical research. Maybe we can use archival data on this, but case studies, other sorts of qualitative research methods can also be very helpful in exploring the issue that you mentioned here, the formation of international law itself. And on the issue of bias, and thanks again for this point. Yes, I think we're all human beings. We all come we all have certain sort of bias with us. But I think for as social scientists, what I'm talking about more here is we should be conscious of the bias, the normative bias that we come when examining a question, and especially because, as I mentioned, the stakes here are high. This can be used to inform policy making, institutional reforms. So we should be conscious of the bias. And for empirical research, we should always ask, well, are there alternative stories are, what are the counterfactuals? Are there alternative stories that can explain the correlation, the phenomenon that we observe, and to use methods to explore those and rule out those alternative stories. So I would say a very rigid empirical method would be helpful for us to mitigate the biases that all of us share. Yeah. Thank you.
Terrific. Well, we've come perfectly to the end of our time for this panel, so we're going to should I turn it back to you, Jared?
Sure. Thank you very much, Professor Ginsburg, for moderating, and thank you, Professors Akinkugbe, Powell, and Rao for this wonderful conversation, and thank you, everybody, for sending in your questions.